You've just been named executor of your parents' estate. The attorneys walked you through the process, handed you some paperwork, and somewhere in all of it, they mentioned you'll need to sell the house. What they didn't tell you is everything that happens between that moment and closing day. And if you're not ready for it, it can cost you time, money, and a lot of unnecessary stress. And now you're sitting there thinking, okay, but how does this actually work? Selling a home in California probate is not like selling a regular home. There are legal requirements, court timelines, and steps that have to happen in a specific order. If you skip one or get them out of sequence, it can cost you months and real money. So in this video, I'm going to walk you through the entire process from start to finish, step by step, so you know exactly what to expect and when. This situation comes up more than most families expect, and it creates some of the most complicated, emotionally charged conversations I've ever seen in estate real estate. So let's walk through exactly what your options are, what the law actually says in California, and how families find a way through it. If you're already in the middle of this and you just need someone to talk to, someone who handles this every day, there's a link in the description. No pressure, just a conversation. But right now, let's get into the steps. Step 1, know what authority you have before you do anything else. Before you call a realtor, before you clean out the house, before you do anything, you need to know what kind of authority the court has granted you. In California probate, there are two types, full authority and limited authority. Full authority comes from something called the Independent Administration of Estates Act. If you have full authority, you can sell the property without going back to the court for approval. The sale still happens inside probate, but you don't need a judge to sign off on every transaction. This makes the timeline significantly shorter and the process a lot more straightforward. Limited authority means the court has to confirm the sale. There's a hearing. There's a process called overbidding where other buyers can show up in court and bid against the offer you already accepted. It adds time, adds uncertainty, and requires a different pricing strategy. How do you know which one you have? Your letters of testamentary or letters of administration. The court document the court issued to you will indicate your authority level. If you're not sure, your probate attorney can tell you in about 30 seconds. This one piece of information shapes every decision that comes after it, so know it first. Step 2, get the probate referee appraisal. California law requires that probate property be valued by a court-appointed probate referee. This is not the same as a real estate appraisal, and a lot of families confuse the two. A probate referee appraisal is a legal valuation, typically based on the fair market value as of the date of death. It's used by the court to establish the minimum acceptable bid if your sale is going to require court confirmation. This happens early in the probate process, often well before you're even thinking about listing the property. Your probate attorney coordinates it. It's not something you hire separately. Here's the important thing to understand. The probate referee's value and what the market will actually pay today are often two different numbers. That's completely normal. The probate referee is establishing a legal baseline at a specific point in time. Your realtor is working with where the market is right now, and these can be significantly different. Step 3, prepare the property. But be realistic about what that means. Most probate homes are sold as is. The heirs don't live there, there's typically renovation budget, and in many cases, the home hasn't been updated in 20 or 30 years. Here's what I tell every family. You don't have to make the house perfect, But you do have to make it presentable, and you have to disclose what you know. California requires full seller disclosure, even in probate. You are required to disclose known material defects. If you know the roof leaks or the heater hasn't worked in 3 years, that has to be in writing. What you're not required to do is fix everything. My recommendation is always a targeted approach. Address any active safety issues. Do a thorough clean out, and I mean a real clean out, because buyers form strong impressions fast. Then focus on the front door and the first room they walk into. That's where value is made or lost. If you don't know where to start with the property condition, with vendors, with any of it, that's part of what I help families figure out. The link in the description is always there. Step 4, price it right and list it with someone who understands probate. This matters more than most families realize going in. A probate listing is not just a regular listing with a different disclosure form. The marketing language, the buyer expectations, the timeline management, all of it is different. And pricing has layers. In probate, you are looking at current market conditions, the condition of the property, and your legal situation. If you have full authority, you have pricing flexibility, similar to a standard sale. If you're headed to court for confirmation, pricing strategy is tied directly to the overbid threshold. There's the rule most people don't know. Under court confirmation, the minimum overbid at the hearing is 10% of the first $10,000 of the accepted price, plus 5% of the amount above that. And there's a statutory formula. Your realtor also needs to set buyer expectations up front. Probate buyers need to understand they may be waiting 30 to 60 days before they even get to a confirmation hearing. Buyers who don't know what they signed up for sometimes walk away mid-transaction. A good probate realtor has the conversation before the offer is signed. Step 5, accept an offer and know what comes next. Once you receive offers, you evaluate them the same way you would in any sale. Price, contingencies, financing type and terms. Your realtor walks you through the comparison. Here's where it splits based on your authority level. If you have full authority, you accept the best offer, open escrow, and send out a notice of proposed action to the heirs. That notice gives them a set window, typically 15 days, to object. If no one objects, the sale moves forward and closes without any court involvement. If you have limited authority, you accept the best offer, and then your attorney petitions the court for a confirmation hearing. At that hearing, the judge reviews the sale, but any member of the public can walk in off the street and place an overbid above the statutory minimum. The original buyer loses the sale. They typically get their deposit back, but they're out. This is why you want the right buyer going into a limited authority sale. Not just the highest price, but a buyer who is prepared, committed, and understands what they're walking into. Court confirmation hearings in California take typically 30 to 60 days to schedule after the petition is filed. Sometimes longer, depending on the county and the court's calendar. Plan for it. Don't promise your buyers a close date you can't control. Step 6, close escrow and understand where the money goes. Once the sale is confirmed, whether through a full authority process or through the court hearing, escrow closes like any other real estate transaction. Title transfers, closing costs are paid from the proceeds. The net funds are wired to the state account, and then they stay there. This surprises a lot of families. The house closes and they're expecting checks, but the sale proceeds don't go directly to the heirs at closing. They become part of the estate assets and are distributed when the court approves the final accounting. At the end of the probate process, depending on where you are in the overall timeline, the distribution could still be months away. Your probate attorney manages the final stage. As a probate realtor, my job ends at closing, but knowing that in advance means you're not blindsided when the sale is done and the money isn't in anyone's hands yet. That's the full process, 6 steps. Know your authority, get the probate referee appraisal, prepare the property realistically, price and list it with the right person, navigate the offer and confirmation process, close and understand the distribution timeline. I want to say one more thing before I let you go, because this comes up in almost every conversation I have. Probate is not just paperwork, it's your families working through one of the hardest seasons of your lives. Often while you're grieving, often with siblings who don't see things the same way, often without anyone explaining what's actually happening in plain English. The families who feel most overwhelmed when they reach me aren't always the ones dealing with the complicated estates. They're often the ones who just don't have anyone in their corner walking them through it. Someone who isn't billing by the hour, who isn't speaking in legal language, and who actually knows what to do with the house. That's what I do. Attorneys handle the legal side. I handle the real life side. The property decisions, the vendors' coordination, the family's conversations, the timeline management. I'm the person you call when you have the house and you're not sure what to do next. If that sounds like where you are, the link in the description is the best way to reach me. And I do mean reach me, not a form that goes to an assistant. If this video helped you, give it a like. It helps other families in the same situation find it. Subscribe if you want more content like this, because I make these every week, especially for families navigating inherited property in California. And if there's a question that I didn't answer here, leave it in the comments. I read all of them, and your question might become the next video. I'll see you in the next one.